Na mkabisa tunarudi moja kwa moja katika mahakama ya upeo ili kuweza kusikia kinachoendelea ndani ya mahakama hiyo, maana Wakenya wengi wameweza kukodoa macho katika sehemu hiyo ili kuweza kujua mwelekeo utakaweza kutolewa na mahakama ile endapo spika wa bunge la kitaifa na ule spika wa seneti wataweza kuhusishwa katika kesi ambayo inazungumzia ugavi wa fedha katika kaunti zetu. Tuende moja kwa moja ambako Chemutai Ngweni yuko huko tuweze kujua kinachoendelea.
So Parliament are required to take. We want to hear of the position in the matter.
My lords, my lady, on account of the Senate, you will be addressed by Professor Ubishi.
Use the microphone on your left. It's nearer.
Thank you, my lords and my lady. The Senate has largely complied with the directives of the court. Was by the last time when we were here, the bill, that is the Division of Revenue Bill, which was which had been initiated by the National Assembly, had collapsed. Since then, we have had a process whereby each house, and may I say, my lord, we have filed this report in terms of an affidavit which has been sworn by the clerk of the Senate on behalf of the Speaker and the directions and authority of the Speaker of the House. So, my lord, each of the two houses did initiate their own version of another fresh Division of Revenue Bill. And the first to do so was the Senate. And the reason why we initiated a fresh bill, my lord, is two reasons. One, because this court did advise in advisory opinion number 2 of 2013 that the Division of Revenue Bill is an ordinary bill. That was the decision of the majority, and therefore it can originate from either house. Secondly, because we wanted to hasten the process, so we very fast initiated a bill. That bill went to the National Assembly and was read the first time, but was withdrawn at some point by the National Assembly through a communication from the Speaker. So, as we were trying to figure out what to do next, we received another version from the National Assembly. And Senate, always being the sober house that doesn't want to get to mess up national processes like this one, we did process the Division of Revenue proposals that came from the National Assembly, notwithstanding that they had withdrawn our own version. The status as we speak now, my lord and my lady, is that the two houses have been unable to agree. The figure that came from the National Assembly was amended by the Senate, and therefore yesterday, we did get a message from the National Assembly conveying the rejection of the Senate amendments, and therefore the mediation process is supposed to commence on this version of the bill. This morning, we have received the proposed names of members of the mediation team from the National Assembly, and immediately after this session, we will be conveying also our names of mediators. Therefore, largely, my lord, the process is at the tail end, because hopefully that mediation should be able to generate some consensus, hopefully. The second point, my lord, I want to report to the court, which is not in the affidavit, is that the Senate also passed a resolution on 7th of August, not really a resolution, but the Speaker did direct the Committee on Finance and Budget of the Senate to convene a consultative forum involving all the key stakeholders, namely the Cabinet Secretary for the National Treasury, the Attorney General of the Republic, the Controller of Budget, the Council of Governors, and this did happen. This forum did happen on Tuesday. And that forum, I'm happy to report, my lords and my lady, did generate some progress in the form of the Treasury agreeing that since the money being contested is less than, or rather what is being contested, the minimum proposal is 316 billion from the National Assembly. So it was agreed that the National Treasury can release any money which is less than that minimum. Although that proposal again was amended thereafter to provide that the Treasury will only release a figure up to what was disbursed to counties last year as an interim measure without prejudice to the ongoing negotiations. And then the negotiations, of course, will arrive at a final figure. But that was made subject to an advisory being done by the Attorney General, which we are waiting for today. And therefore, I'm happy to report there could be some progress again informally, where counties can ameliorate the crisis by accessing some funds, which cannot exceed half, 50% of 314 billion, which is the amount which was released last year. Finally, my lords and my lady, in view of those two developments, it is our considered view, that this court, in spite of the progress made, should continue and help the country in terms of determining this reference, because there are broader issues that are not necessarily directly touching on the division of revenue bill of 2019. And therefore, for posterity and for the sake of strengthening, entrenching devolution in this country as a key component of our constitutional order, it is our humble submission that in spite of the progress made, in spite of the possible compromise and possible mediated outcome of the bill, in spite of the counties being able to access some funds in the interim, this court should continue and hear the parties and make a determination in this reference. That's all, my lord and my lady. This affidavit, my lord, should be on the record. It is sworn in by Eunice Kishangi, who is the senior deputy clerk of the Senate, under the direct instructions authority of the Speaker of the Senate, who is out of the country. So it should be put on record, my lord. That's all, my lord and my lady. Thank you.
Yes, who is appearing? Who is Mr. Mwendwa? Speaker, oh, yes.
Good morning.
Yes, Madam, your name again was?
Mr. Dara. I'm holding brief for Mr. Mwendwa and Mr. Mbarak, who appear for the Speaker of the National Assembly.
Okay.
My lords and lady, this is just to confirm that the National Assembly complied with your previous directions. We have filed and served a status report, and my instructions are to ask this honorable court to give us time to mediate. As my senior has already stated before you, we've come up with names for members of the mediation committee. from the National Assembly. We await the names of the Senate, and we just ask that you give us the 30 days as provided in Article 113 of the Constitution. Thank you.
Yes, what do the other parties say? Mr. Ngatia?
My lords, what has happened today is what we anticipated last time, but for purposes of the record, in March this year was the Division of Revenue Bill, which was published by National Assembly. Soon thereafter, rejected by the Senate. Soon thereafter, a mediation exercise, and all that collapsed. Then, as Professor has indicated, Professor Kindiki, Senate this time originated the bill. In the process, National Assembly originated another bill. Professor Kindiki is quite emphatic. There is disagreement, and the question that this court will now wish to consider is whether we do the second circle of Article 113, the second circle of 113. Let me start by saying this, my Lord Chief Justice. The petition before you raises not only broader issues, but raises issues beyond shillings and cents. We are not here because of amount A or amount B. We are here because certain primary organs of state are unable to agree and see the way forward regarding certain constitutional provisions. Each of the three organs of state sees this differently. National Assembly has its own view, Senate has its own view, the Committee on Allocation of Revenue has its own view. So even if we were to do several circles of the so-called mediation, those issues remain unresolved. And in my submission, in this republic, the only organ that has a legal competence is the apex court. So my first request is, please allow us this opportunity. We've been knocking on the door of this court for a hearing of the petition. As regards whether, my Lord, you can give a second circle of mediation, my very firm position is as follows. As I read the budget circle, the budget circle in this republic starts in August of every year. The next milestone is March of the following year, when Division of Revenue Bill ought to be published. And the circle, the whole circle should end on or about June of that year. We are now in August. As a matter of fact, the 2020 finance bill ought to now have kick-started the process. My reading of Article 113 indicates to me that there should only one mediation, because mediation cannot be a circular process. Only one. We are now being invited to wait for a second one. I do not see that as a possibility, because the budget process is an annual process, starts in August of the year and ends in June the following year. I'll therefore request this noble court, whatever amelioration measures are going on, those are amelioration measures that should go on, but more importantly, let us have the constitutional process adjudicated by this court. Please do not allow devolution to be threatened, because the circle of mediations and mediations, the biggest victim will be devolution. Devolution will be the victim. In that process, we all become victims of tough wars which should not be there. And it's only this apex court that can really adjudicate on those tough wars. I think, my Lord, I have stated our position as clearly as I could.
May it please my Lord,
Yes.
On behalf of the Commission for Revenue Allocation, I think it's important, my Lords, to recognize that while we appreciate the efforts that are being made by the two houses, that this process has not started in June, July, or August. This process actually started in February. There have been mediations, informal and formal, from the end of February when when this process started. Actually, as far as I know, probably even earlier. Our concern, my Lords, is that while the mediation processes must be encouraged, those mediation processes must not lead to a process that subverts the Constitution, fundamentally subverts the Constitution. And my Lords, the reason why the Council of Governors and my clients appeared before this court is recognizing that part of the reason why the mediation so far have failed to produce result is that they operate on a tabula rasa. They operate without defined principles. And so the possibility that two people who have disagreed get into a room without principles and are expected to agree again on issues they have disagreed before is difficult to comprehend. So why we came to this court, my Lords, my lady, is so that this court can establish certain principles that will guide the negotiations. That is what would help an effective resolution of this problem. My Lords, my lady, when the executive, the one arm of government, when the national legislatures are unable to comply with the Constitution, the principles of the Constitution, where else do parties who are affected go? That is the reason why we are before you. If the matter is passed back on to these institutions, we leave ourselves at the mercy of institutions that have been unable to agree up to this point. And what we're asking, my Lord, is this court helps us establish principles that will resolve this year's problems and future problems. The final point, my Lord, I want to make is I'm concerned by the casual manner in which this matter of release of money to counties is being handled. The truth of the matter is that the process of release of monies to counties is a constitutional matter. It's a constitutional matter. There are constitutional principles. The Treasury, the COB, the Senate cannot sit in a room and agree to subvert the constitutional process. For the counties to be able to appropriate any money, they must pass an appropriation law. For them to pass an appropriation law, there must be a CARA, the Revenue Allocation Act. You cannot have a CARA without the division of revenue. So ultimately, even if the money was available, the counties cannot appropriate legally. So what is being proposed is a process that will subvert the law, whatever opinions are given by any party. So what we are saying is, let us resolve the constitutional issue constitutionally, not informally. And let us recognize that release of money to counties is not at the discretion of institutions. It is not discretional, it's constitutional. So let us go the constitutional route. And the constitutional route can only be enforced by this court, nobody else. And so we are asking, my Lord, in the context in which we are in August and we have not released monies to counties since the beginning of July, this court gives us a way forward by resolving the principles that we have asked for in the petition. Much obliged, man.